Welcome to the AI Law Briefing Podcast.
Disclaimer. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice.
Okay, let's jump right into this. Today, we're diving deep into a whole stack of sources.
Yeah, we're covering the latest shifts in AI development, new tools hitting the market for legal professionals, and the regulatory scene, which is, well, moving fast.
Especially in the EU and specifically Luxembourg, right?
Exactly. Our goal here is really to cut through the noise for you.
Think of this as your shortcut, helping you understand the practical side of things, what these changes mean for your practice, the regulations you need to watch, and how to even evaluate these AI tools.
Especially for you, our audience of sophisticated legal pros.
First up, let's look at the AI frontier itself. What's been happening, say, this week that's relevant for the legal sector? There seems to be a move away from just basic chatbots.
Definitely. What's really interesting is this shift towards AI agents. These aren't just answering one question, they're designed for multi-step tasks. Think more complex workflows.
That sounds powerful, but maybe more complex, more risk.
It absolutely introduces new layers, especially if you start connecting these agents to, sensitive client data.
Which leads to this trend towards specialization, I suppose.
Precisely. It's less about finding the smartest AI and more about finding the tool that's built for legal work, secure, and crucially reliable.
Okay, reliability. That brings us straight to a pretty major security issue that surfaced this week.
Yes, a big one. Microsoft disclosed the Echo Leak vulnerability, that's CVE 2025-32711, impacting Microsoft 365 Copilot.
And this was serious, like critical level.
Critical and zero-click, which means a user didn't even have to click anything malicious. Just receiving a bad email could trigger it.
Wow, how did that even work?
It's a type of indirect prompt injection. Basically, a crafted email could hide instructions. Later, when Copilot was working with your internal data, its retrieval system could accidentally pick up those hidden commands from the email.
So the AI could be tricked into leaking your own confidential data based on an email it saw earlier.
Exactly, mixing untrusted external stuff with your private info, potentially leaking it.
So was it fixed? Is it still a danger?
Thankfully, yes. It was addressed in the June 2025 Patch Tuesday update, and there's no sign it was actually exploited out there.
Okay, good. But for lawyers, that's still a huge red flag, isn't it?
It really is. It just shows how even major vendors can have these, fundamental design flaws leading to silent data leaks.
Underscores the need for serious security vetting of any AI touching client data.
Absolutely critical. Non-negotiable, really.
Okay, moving on. Let's look at updates from the big AI players. OpenAI had some news.
Yeah, they launched their O3 Pro model on June 10th. It's available for Pro subscribers in the EU through ChatGPT and the API.
And the focus is on advanced logical reasoning.
That's the pitch. Designed for more complex tasks, which you can see being relevant for legal analysis, maybe even drafting certain technical things.
They also updated ChatGPT projects.
Right. Aiming for better memory in the system so you can work on longer tasks, and it remembers the context better. More persistent.
But it wasn't all smooth sailing for them this week, was it?
No, they admitted to some rare hallucinations in their advanced voice mode, basically. Unintended audio outputs. And maybe more significantly, they had to roll back an update to their O4 mini model because it was triggering too many content flags. Suggests some quality or safety issues they hit.
And this is a really crucial point for our EU listeners. There's a U.S. court order causing a major headache with GDPR.
This is a big one. Because of ongoing litigation, a U.S. court is forcing OpenAI to keep all consumer ChatGPT and API customer data indefinitely.
Indefinitely. How does that square with GDPR's right to erasure or data minimization?
It doesn't. It's a direct conflict.
So for an EU law firm using these tools,
it creates a very real compliance and data privacy risk for any client confidential information that goes through those systems. You absolutely need to be aware of this U.S. legal hold situation.
Okay, so while OpenAI navigates that, Google seems to be making a push, maybe partly reacting to security concerns like Echo Leak.
They've certainly been active. Gemini 2.5 Flash became generally available early June, with Gemini 2.5 Pro right behind it.
New features too. Thought summaries, deep think.
Yep. Those are some of the new capabilities, and they're really embedding the stuff into their ecosystem.
Right, integrating generative AI directly into workspace business and enterprise plans now.
Exactly. No separate AI add-on needed for those tiers, which really lowers the barrier if your firm uses Google Workspace.
Easier adoption.
For sure. They even started testing audio overviews for search results around June 13th.
And after that Microsoft vulnerability, Google made a point of talking up their security.
They did. Put out a detailed overview of Gemini's defenses. Things like proprietary classifiers against bad prompts, markdown sanitization to stop data leaking via images.
Clearly positioning themselves as the secure option for businesses worried about risk.
Seems like a very strategic move, yes.
Is everything available in the EU right away, though?
The core Gemini stuff in Workspace is global. But some of the newest search features, like that AI mode, started US only. So there might be a bit of a lag for some cutting-edge things in the EU.
Let's quickly touch on Anthropic. They had an interesting, maybe cautionary experience this week.
Yeah, they launched a blog called Claude Explains, AI-generated content, but with human review.
And?
They shut it down within a week.
Wow. What does that tell us?
Well, it strongly suggests the human effort needed for proper fact-checking and editing, to make it trustworthy for public consumption, was just too high. It outweighed the automation benefits.
So a real warning for firms thinking AI can just churn out marketing content or knowledge-based articles without serious human oversight.
Exactly. Humans are still very much needed in the loop for quality control. On the other hand, Anthropic also published some really promising research on multi-agent systems.
Where multiple AIs work together.
Right. And they reported a huge performance jump, like 90.2% better on their internal tests compared to a single AI model.
So the future might be AI teams tackling complex legal work.
It certainly points in that direction. A glimpse of how AI might scale for really big tasks.
And they're also expanding in Europe. Dublin, London.
Yes, signaling a clear commitment to the European market, hiring plans in both cities.
We've mentioned OpenAI and Google. Our sources had a comparison table. What are the key takeaways for lawyers trying to choose?
Looking at that comparison, it really hammers home that the best choice depends entirely on what you need it for.
So O3 Pro from OpenAI is positioned for
strong logical analysis, think complex legal reasoning, mapping out arguments in detail.
Whereas Google's Gemini 2.5 Pro
shines more with multimodal tasks, handling images, audio, etc., and crucially, that deep integration within the Google Workspace ecosystem. If your firm lives in Google Workspace, Gemini is likely a smoother fit.
Makes sense. Native integration is a big plus there.
Definitely. OpenAI has APIs and connectors, but it's not built into a core Office suite quite the same way.
And that data sovereignty point we discussed, that U.S. court order versus GDPR.
That's probably the starkest difference highlighted in the comparison. OpenAI's current situation with that indefinite data retention order creates a significant GDPR conflict and risk for EU firms.
While Google, though, still a U.S. company,
is emphasizing its security and EU infrastructure more. The comparison suggests firms prioritizing data sovereignty might lean away from OpenAI currently because of that direct GDPR clash.
And availability of the very latest features isn't quite parallel either.
Right. OpenAI's O3 Pro rolled out to EU Pro users immediately. Some of Google's newest search AI features had that initial US-only phase.
Okay, this whole discussion about reliability and data sources leads perfectly into our deep dive topic, Retrieval-Augmented Generation, or RAG. This seems foundational for making AI actually usable in law.
Absolutely essential. RAG is the key technology tackling the biggest problem with standard large language models in a legal context, hallucination.
Where the AI just confidently makes things up, right? Sounds plausible, but it's wrong.
Exactly. Standard LLMs rely on what's called parametric memory. Think of it as knowledge frozen at the point they were trained.
So if a law changed last month, an LLM trained last year is just unaware.
Precisely. It doesn't know about post-training updates.
Yeah.
And worse, when it doesn't know the answer from its frozen memory, it doesn't say, I don't know. It generates something that sounds right, but could be completely wrong factually.
And studies show this happens a lot in legal tasks.
Frighteningly often. One study mentioned found even top LLMs hallucinated over 49% of the time on legal queries back in June 2024. That's fundamentally untrustworthy for professional work without safeguards.
Okay, so how does RAG provide that crucial safeguard?
RAG changes the whole process. Instead of only using its internal frozen memory, the system connects the LLM to an external, trusted, and this is key, current knowledge base.
Like your firm's own documents
Yeah.
or a live legal database.
Exactly. Your document management system, case law databases, internal precedents, whatever you designate as trusted.
Walk me through how it works when I ask a question.
Okay, it's basically a two-step workflow. First, retrieval. Your question doesn't go straight to the LLM's brain. The system first searches your trusted knowledge base, your firm's documents. For instance, finds the relevant passages or chunks of text.
So it finds the facts first.
Right. Then step 2, generation. The system takes your original question and augments it, packaging those retrieved facts with the question. It then tells the LLM, answer this question, but base your answer only on these facts I just gave you.
So the answer is grounded in specific, verifiable information from your sources, not just pulled from the LLM's vast, potentially outdated training data.
Precisely. That's the term grounded answers.
Yeah.
And critically for legal work, a good RAG system provides citations, pointing you back to the exact source document for verification. It acts as a shield against those dangerous hallucinations.
How does actually implementing RAG change how lawyers work?
The big win is connecting the LLM's reasoning power to information that's both up-to-date and confidential without exposing that confidential data to the AI vendor or using it for their model training.
So you can use AI on your internal case files safely.
That's the goal. It enables use cases that were previously too risky or unreliable.
Like what, for example?
Things like rapid due diligence, pulling specific clauses from hundreds of contracts, or legal research getting synthesized answers from statutes and case law, but with direct links back to the sources.
Makes sense.
Also, evidence retrieval from case files based on concepts, not just keywords. And contract comparison, checking drafts against your firm's standard playbook or past deals, automatically flagging differences.
And there's an evolution called agentic RAG.
Yeah, that's the next level. Agentic RG aims to mimic a human lawyer's multi-step research process. So my retrieve a statute, then find relevant cases interpreting it, then cross-reference internal memos on the topic, all from one initial prompt. More sophisticated reasoning.
So if you're a firm evaluating AI tools, what are the crucial questions to ask a vendor specifically about their RAG system, since that seems to be where the reliability comes from?
Absolutely. The RG part is key. You need to ask things like, what exact knowledge sources can this system access? Can it securely connect to our specific DMS, I manage SharePoint, whatever we use?
Good point.
How do you keep any external data sources, like public case law, up to date? How does the system handle conflicting information if different sources disagree?
Important one.
Does it provide clear, verifiable citations for everything it generates? And crucially, what are the technical and contractual guarantees that our confidential data stays private and isn't used to train your underlying AI models?
So RAG isn't just a fancy feature. It's the core technology making generative AI actually viable and trustworthy for legal work.
That's the takeaway. It addresses the hallucination crisis, builds that necessary trust layer. Studies confirm RE systems significantly improve quality and reduce errors in legal AI output.
And when you're evaluating vendors, the real focus should be less on the underlying LLM itself and more on how good the retrieval system is at accessing your information securely and accurately.
Exactly. The LLM models are improving rapidly across the board. The real differentiator, the thing that delivers ROI and reliability, is that retrieval component and its ability to integrate effectively with your firm's specific knowledge.
Right, let's bring this closer to home now and look at the lawyer's AI toolkit, especially with our listeners in Luxembourg in mind.
Yeah, we're seeing in-house teams get more comfortable with AI, which definitely puts pressure on law firms to adopt practical tools themselves. Let's look at a couple of different approaches.
Okay, first, imagine we're evaluating a potential new tool called Legora. What's the pitch?
Legora positions itself as a collaborative AI workspace, specifically for lawyers, seemingly targeting top-tier firms. The idea is integrating AI into existing workflows and document systems.
So what would using it actually look like day to day? A typical workflow?
You'd likely start a project, maybe for due diligence, and upload your documents. A key feature they highlight is tabular review.
Tabular review.
Yeah, it turns documents into an interactive grid. You define columns with prompts like find the governing law clause or list the parties, and it processes the documents to fill the grid, letting you compare information quickly across many files.
Okay, that sounds useful for large document reviews. What about drafting?
They offer a Microsoft Word add-in. It acts as a Copilot, suggesting red lines based on your firm's playbooks or helping fill templates using the data it extracted earlier in the project.
And research. Can it search within the platform?
Yes, it has a legal-specific AI assistant that provides cited answers. It can search within the documents you uploaded for that project, potentially connect to your firm's main DMS like iManage or SharePoint, and maybe external databases too.
Now, crucial for our audience, EU readiness, security, data privacy. How does Legora stack up?
This seems to be a major selling point for them. They explicitly state they're GDPR compliant, have ISO 27001 SOD2 certs, and importantly offer regional data processing and hosting within the EU.
Okay, so data can stay within the EU.
Yes, and they also make a commitment that customer data is not used to train their underlying foundation models.
Yep.
That directly addresses those big data privacy and sovereignty concerns for EU firms.
Especially vital in Luxembourg. What about cost? How do you buy it?
It looks like a pure enterprise sales model. No public pricing, you have to request a demo. That usually means negotiated contracts, typical for high-end software aimed at large firms. No mention of a free trial either.
Okay, so that's one approach, a dedicated high-end platform. Let's contrast that with mastering a tool many firms might already have, like Clio.
Right, this is more about leveraging AI within your existing setup. For firms using Clio, it's your cloud-based practice management, hub managing matters, documents, time, billing, the core digital case file.
And they've added AI capabilities.
Yes, through Clio Duo. It's an AI assistant built right into Clio Manage, using Microsoft Azure OpenAI's GPT-4 model underneath.
The key advantage being?
It works securely with the data you already have stored inside your Clio system. Less friction, potentially lower security hurdles if you're already comfortable with Clio security.
How would a lawyer actually use Clio Duo practically? Give me some examples.
Okay, you could open a long document within a case file, go to the Duo chat panel, and ask it to summarize the document, maybe focusing on key deadlines or action items.
Useful.
Or you could ask Duo to draft an email based on case details you provide in the chat. Or even ask it to analyze your caseload. What are my most urgent priorities across all matters today? And it can scan your deadlines and calendar to give you a list.
So AI integrated directly into the workflow using existing data securely?
Exactly. It brings AI capabilities into a familiar environment.
So comparing Legora's strategy with Clio Duo's, what does it tell us about the market?
Well, Clio, integrating AI into its main subscription, seems aimed at democratizing AI, making it accessible for a broader range of firms, including small and mid-sized ones.
Whereas Legora?
With its enterprise focus, no public pricing, emphasis on integrations like iManage, is clearly targeting the larger top-tier firms with potentially bigger budgets and more complex integration needs.
So the choice really depends on the firm's profile.
Size, current tech stack, budget, specific needs, absolutely.
And that readiness point, Legora, emphasizes regional hosting. No model training on customer data. That's becoming a critical differentiator, especially in Luxembourg, isn't it?
Hugely important. It's a direct answer to EU data sovereignty concerns. And we see this reflected in actions by regulators themselves, like the CSSF in Luxembourg partnering with Clarence, a sovereign air-gapped cloud.
Right. The financial regulator choosing that kind of setup sends a powerful message.
It really does.
Yeah.
For firms in Luxembourg, especially dealing with financial clients, a vendor's documented ability to keep data within the EU and handle it according to strict privacy standards is becoming table stakes, a non-negotiable. The CSSF's own move sets that expectation.
Okay, let's shift to our final section, the regulatory horizon. New AI laws and rules impacting Luxembourg and the EU. The big one, obviously, is the EU AI Act.
Yes. Regulation EU 2024-1689 is now published. It sets up that EU-wide framework based on risk levels. High risk means stricter rules, simple concept, complex execution.
What are the main things legal professionals need to get their heads around with this act?
Several key areas. First, high-risk systems. The Act explicitly includes AI used in the administration of justice. Think legal research tools, document analysis, case prediction tools as high risk.
So using those tools triggers extra obligations.
Yes, stringent requirements for data quality, transparency, human oversight. Same goes for AI in employment, like CV screening tools. Second, transparency obligations. You'll need to be clear when people are interacting with AI, like a client chatbot, and you have to label AI-generated content like deepfakes. This impacts client comms, marketing, everything.
And rules for the big AI model providers, too. OpenAI, Google.
Yes, obligations on them regarding technical documentation, providing info to developers using their models, and being transparent about their training data.
What are the key deadlines we need to track?
Okay, some things kick in relatively soon. That's AI 2 2025. That's when rules on the governance structure, the AI board, the AI office penalties, and those obligations for the big general-purpose AI providers take effect.
And the main rules for high-risk systems used by firms.
But those become fully applicable across the EU later, on August 2, 2026. So there's time to prepare, but the clock is ticking.
And Luxembourg isn't waiting for 2026. They're already setting up their national structure.
That's right. They've submitted Bill N-Degrees 8476. This designates which national authorities will be responsible for enforcing the AI Act in Luxembourg. Interestingly, they're mostly using existing sector regulators.
Not creating one single new AI agency.
No, leveraging existing expertise. A key development in the bill is the mandate for these authorities to set up AI regulatory sandboxes.
What's the significance of that?
It offers a controlled space for legal tech companies and law firms in Luxembourg to test innovative AI solutions under regulatory supervision. It's meant to encourage responsible innovation.
Which authorities should lawyers in Luxembourg be most aware of under this new bill?
The CNPD, the Data Protection Authority, is key. They're the central coordinator and default body. Then, depending on your practice, the CSSF for Financial Services AI, the CAA for Insurance, the JSA for Judicial System AI, and others. The CNPD and CSSF will likely be most relevant for many.
The CSSF's actions really do signal their focus here.
Absolutely. They just published their second thematic review on AI and finance with the central bank. But the big move, as we mentioned, is signing up to use Clarence, that sovereign cloud, for their own internal AI work.
The regulator using a sovereign cloud definitely sends a message about expectations.
It's a very clear signal, especially to the financial sector they supervise. It strongly indicates their expectations around data sovereignty and security when firms procure AI solutions. Sets a de facto standard.
Okay, shifting gears slightly, but still regulatory, there's an urgent deadline from the AED concerning AML-CFT reporting.
Yes, this is critical and needs immediate action if it applies to you or your clients. The AED has expanded reporting for unregulated alternative investment funds, AIFs, that fall under their AML-CFT supervision.
What's new? What reports are needed?
2 new annual reports are required. An AIF AML questionnaire, it's an Excel file, and a separate annual report from the fund's RC, responsible for compliance.
And the deadline is?
June 30, 2025. That's for the financial year that ended in 2024. So the deadline is basically now. Immediate action required.
What does this mean practically for firms advising these funds?
It forces a review and likely update of operational documents, risk assessments, policies, procedures for due diligence on investors and assets, delegation agreements. It also demands quite detailed statistical data, really testing data governance.
Sounds like a strong argument for better digital compliance systems.
Definitely pushes firms in that direction.
Yeah.
Managing this kind of granular reporting manually is tough.
And finally, on the regulatory front, we can't ignore the Court of Justice of the EU, CJEU. They've had some important rulings.
Yes, continuing to shape the digital landscape. One key ruling clarified the GDPR right to meaningful information about the logic used in automated decisions.
Meaning
just giving someone a complex mathematical formula isn't enough. The explanation has to be actually understandable to the person affected. And significantly, companies can't just hide behind trade secrets to avoid explaining.
that seems like a direct challenge to opaque black box AI, doesn't it?
Yeah.
Especially for important decisions.
It really pushes towards explainable AI.
Okay.
XAI, needing systems where you can explain the why behind an AI-driven decision, particularly high-stakes ones. The CJEU also confirmed how maximum GDPR fines are calculated.
Yes, the big numbers.
They confirmed it's based on the total worldwide turnover of the parent company's entire corporate group. It reinforces that economic unit idea liability flows upwards. Big potential exposure.
So parent companies need to be very aware of subsidiaries' GDPR compliance.
Absolutely. And interestingly, the AI Act itself is already facing CJE scrutiny even before it fully applies.
Really? How?
A case, C80624, has been referred from Bulgaria asking about the Act's rules on automated decision-making. So key parts of the Act will likely be legally tested almost immediately. But the big picture here, especially for Luxembourg's financial sector, is this convergence. Financial regulation and tech AI regulation are now deeply intertwined. The CSSF, the AEDs, they're acting as both financial and AI regulators simultaneously.
Creating demand for advisors who understand both worlds.
Exactly. You need fluency in both finance and tech law now.
Okay, so bringing our deep dive together today, we've seen AI tech evolving fast agents, specialization, but also critical security risks like echo leak.
We really hammered home the importance of RAG, Retrieval-Augmented Generation, as the bedrock for making AI trustworthy in law. Solves that hallucination problem.
We looked at specific tools, Legora, targeting the high end with a strong EU data focus, Clio Duo, integrating AI into existing platforms, highlighting how vendor choice depends on your needs and how crucial that data sovereignty piece is becoming, especially in Luxembourg.
And finally, we navigated that complex regulatory landscape, the AI Act rolling out, Luxembourg setting up its authorities and sandboxes, that urgent AED deadline, and key CJEU rulings demanding transparency and confirming high stakes for non-compliance.
Staying informed on all this isn't just nice to have. It's vital for your practice, for compliance, managing risk, and actually using these powerful new tools effectively and responsibly.
Absolutely critical to stay ahead of the curve.
So here's a final thought to leave you with. Considering the CSSF's very deliberate choice of a sovereign air-gapped cloud for its own AI work, and the relentless regulatory push across the EU for data control and transparency, what does that signal about the level of fundamental trust required in the AI systems you choose to use with your client data? And maybe more importantly, how will you rigorously vet your AI vendors going forward to meet not just the rules, but these evolving expectations of deep trustworthiness? Hit that like and subscribe button.
Disclaimer. This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice.
It was the AI Law Briefing podcast for you this week.